My dear fellow citizen, I am coming with the directive principles of state policy in the series of our Constitution. Part 4 of the Constitution, Article 36 to 51, contains the directive principles of state policy. As shown in Table 6, these principles may be classified under several groups. Certain ideals, particularly economic, which according to the framers of the Constitution, the state should strive for. Certain directions to the legislature and the executive intended to show in what manner the state should exercise their legislative and executive powers. Certain rights of the citizens which shall not be enforceable by the courts like the fundamental rights, but which the state shall nevertheless aim at securing by regulation of its legislative and administrative policy. It shall be at the duty of the state to follow these principles both in the matter of administration as well as in the making of laws. They embody the object of the state under the Republican Constitution, namely, that is to be a welfare state and not a mere police state. Sorry. Most of these directives, it will be seen, aim at the establishment of the economic and social democracy which is placed for the in the preamble. According to Sir Ivor Jennings, the philosophy underlying most of these provisions is Fabian socialism without the socialism, for only the nationalism of the means of production, distribution, exchange is missing. This much is clear, however, that our Constitution, as framed in 1949, did not adhere to any particular ism but sought to effect a compromise between individualism and socialism by eliminating the vices of unbridled private enterprise and interest by social control and welfare measures as far as possible. This is why socialistic pattern of society. This is why socialistic pattern of society, not socialism, was declared to be the objective of our planning by Pandit Nehru. Socialism to some people means two things: distribution, which means cutting off the pockets of the people who have too much money, and nationalization. Both these are desirable objectives, but neither is by itself socialism. Any attempt to distribute by affecting the productive machinery is utterly wrong. To do so, it would be to weaken ourselves. The basis of socialism is greater wealth. There cannot be any socialism of poverty. Therefore, the process of equalization has to be faced. Secondly, there is the question of nationalization. I think it is dangerous merely to nationalize something without being prepared to work it properly. To nationalize, we have to select things. My idea of socialism is that every individual in the state should have equal opportunity for progress. It must be mentioned in this context that the governmental policy at the union level has demonstrated a greater bias towards collectivism during the regime of his daughter, Mrs. Indira Gandhi, and quite a number of industries, trades, and other means of production were nationalized during the three decades since independence, either directly or through the agency of state-owned or state-controlled corporations, banking, insurance, aviation, coal mines. It should, however, be mentioned that though the objective of the state has been described to be socialist by the amendment of the preamble by the 42nd Amendment Act, Mrs. Gandhi had said that this socialism did not indicate collectivism, but the offering of equal opportunities to all through socio-economic reform. By the same amendment, certain other changes have been introduced introduced in Part 4, adding new directives to accentuate the socialistic bias of the Constitution. Article 39A has been inserted to enjoin the state to provide free legal aid to the poor and to take other suitable steps to ensure equal justice to all, which is offered by the preamble. Article 43A has been inserted in order to direct the state to ensure the participation of workers in the management of industry and other undertakings. This is what is known as profit sharing. This is the positive step in advancement of socialism in the sense of economic justice. The Janata government sought to implement the promise of economic justice and equality of opportunity assured by the preamble by inserting clause 2 in Article 38 by the 44th Amendment Act 1978 as follows. The state shall in particular strive to maintain the inequalities in income and endeavor to eliminate inequalities in status, facilities and opportunities, not only amongst individuals but also amongst group of people residing in different areas or engaged in different vocations. This innocently looking amendment is to be read along with elimination of the fundamental rights to property. They have paved the way for confiscatory taxation and for equalizing salaries and wages for different vocations and different categories of works, which would usher in a socialistic society even without resorting to nationalization in the means of production. Article 38 enjoins the state to strive to promote the welfare of the people by securing and protecting as effectively as it may the social order in which justice, social, economic and political shall inform all the institutions of national life, striving to minimizing inequalities in income and endeavor to eliminate inequalities in status, facilities, opportunities among individuals and groups of people residing in different areas or engaged in different avocations. The directives, however, differ from fundamental rights contained in Part 3 of the Constitution or the ordinary laws of the land in the following respects. While the fundamental rights constitute limitations upon state action, the directive principles are in the nature of instrument of instruction to the government of the day to do certain things and to achieve certain ends by their action. The directives, however, require to be implemented by legislation so long as there is no law carrying out the policy laid down in the directive. Neither the state nor the individual can violate any existing law or legal right under color of following a directive. The directives are not enforceable in the court and do not create any justiciable rights in favor of the individuals. From the standpoint of the individual, the difference between the fundamental rights and the directives is that between justiciable and non-justiciable rights, a classification which has been adopted by the framers of our Constitution from the Constitution of Ayr. Thus, through the directive under Article 43, enjoins the state to secure a living wage to all workers. No workers can secure a living wage by means of an action in a court so long as it is implemented by appropriate legislation. In other words, the courts are not competent to compel the government to carry out any directive as, for example, to provide the free compulsory education within the time limited by Article 45 or to undertake legislation to implement any of the directive principles. It may be observed that the declarations made in Part 4 of the Constitution under the head Directive Principles of State Policy are in many cases of a wider import than the declarations made in Part 3 as fundamental rights. Hence, the question of priority in case of conflict between the two classes of provisions may easily arise. But while the fundamental rights are enforceable by the courts, Article 32 2 and 226 1, and the courts are bound to declare as void any law that is inconsistent with any of the fundamental rights, the directives are not so enforceable by the courts, Article 37. And the courts cannot declare as void any law which is otherwise valid on the ground that it contravenes any of the directives. Hence, in case of any conflict between Part 3 and Part 4 of the Constitution, the former should prevail in court. The foregoing general proposition laid down by the Supreme Court in 1951 must now, however, be read subject to a major exception. Article 31C, introduced in 1971 and expanded by the Constitution 42nd Amendment Act, says that though the directives themselves are not directly enforceable in the courts, if any law is made to implement any of the directions contained in Part 4 of the Constitution, it would be totally immune from the unconstitutionality on the ground of contravention of the fundamental rights conferred by Article 14 and 19. This attempt to confer a primacy upon the directives as against the fundamental rights has, however, been foiled by the majority of the Supreme Court in the Minervaville case in two respects. It has struck down the widening of Article 31C to include any or all the directives in Part 4 on the ground that such total exclusion of judicial review would offend the basic structure of Constitution. In the result, Article 31C is resorted to its pre-1976 position so that a law would be protected by Article 31C only if it has been made to implement the directive in Article 39B to C and not any of the other directives included in Part 4. It has been also held that there is a fine balance in the original Constitution as between the directives and the fundamental rights, which should be adhered to by the courts by a harmonious reading of the two categories of provisions instead of giving any general preference to the directive principles. It is also to be noted that outside these two fundamental rights in Article 14 and 19, the general proposition laid down in 1951 shall subsist. Thus, by way of implementing the directive in Article 45 to provide free and compulsory education to children, the state cannot override the fundamental rights under Article 31 of minority communities to establish educational institutions in their own choice. It has been held that the fundamental rights and the directive principles are the two wheels of the chariot as an aid to make social and economic democracy a truism. It would be an easy task to survey progress made by the governments and the union and states in implementing such a large number of directives over a period of 5 decades since the promulgation of the Constitution. Nevertheless, a brief reference to some of the outstanding achievements may be made in order to illustrate that the directives have not been taken by the government in power as pious homilies, as was supposed by many when they were engrafted in the Constitution. The greatest progress in carrying out the directives has taken place as regards the directive Article 39B that the state should secure that the ownership and control of the material resources of the community are so distributed as best to subserve the common good. The distribution of largesse of the state is for the common good and the subserve the common good of as many persons as possible. In an agrarian country like India, the main item of material resources is no doubt agricultural. Since the time of the permanent settlement, this important source of wealth was being largely appropriated by a group of hereditary proprietors and other intermediaries known variously in different parts of the country, such as jamindars, jagirdars, inamdars, etc., while the actual tillers of the soil were being impoverished by the operation of various economic forces apart from high rents and exploitation by intermediaries. The Planning Commission in its first plan therefore recommended an abolition of these intermediaries so as to bring the tillers of the soil in direct relation relationship with the state. This reform has by this time been carried out almost completely throughout India. Side by side with this, legislation has been undertaken in many of the states of the improvement of the constitution of the cultivators as regards security of tenure, fair rents and the like. In order to prevent the concentration of land holdings even among the actual cultivators, legislation has been enacted in many of the states fixing a ceiling, that is to say a maximum area of land which may be held by an individual owner. It has already been stated how these reforms have been facilitated by amending the constitution to shield these laws from challenge in the courts. A large number of laws have been enacted to implement the directive in Article 40 to organize village panchayats and endow them with powers of self-government. It is stated that there are 2,26,108 gram panchayats, 5,736 intermediate tiers and 457 Jila Panchayats in the country. Though the constitution and functions of the panchayats are according to the terms of the different state acts, generally speaking, the panchayats elected by the entire adult population in the villages have been endowed with powers of civic administration such as medical relief, maintenance and village roads, streets, tanks and wells, provision of primary education, sanitation and like. Besides civic functions, the panchayat also exercise judicial powers. The judicial wing of the panchayat thus has a civic jurisdiction to try cases of a value not exceeding rupees 500 and is also competent to try minor offences punishable with moderate fines. Legal practitioners are excluded from these village tribunals. Though owing to lack of proper education, narrow-mindedness and sectional interests in the rural area, the system of panchayat administration is still under controversy. After the Constitution 73rd and 74th Amendment Acts, almost all the states have enacted laws vesting various degrees of powers of self-government in the hands of panchayat. For the promotion of cottage industries, Article 43, which is a state subject, the central government has established several boards to help the state governments in the matter of finance, marketing and like. These are All India Khadi and Village Industries Board, All India Handicrafts Board, All India Handloom Board, Small Scale Industries Board, Silk Board, Choir Board. Besides, the National Small Industries Corporation has been set with certain statutory functions, and the Khadi and Village Industries Commission have been set up for the development of Khadi and village industries. Legislation for compulsory primary education has been enacted in most of the states and in 3 union territories. For raising the standard of living, Article 47 particularly of the rural population, the Government of India launched its Community Development Project in 1952. Later on, Integrated Rural Development Program (IRDP) 1978-79, National Rural Employment Scheme Program (NREP), Rural Landless Employment Guarantee Program (RLEGP), Drought Prone Areas Program, Desert Development Program, and some other schemes were launched. Though legislation relating to prohibition of intoxicating drinks and drugs, Article 47, had taken place in some of the provinces long before the Constitution came into being, not much of effective work had been done until, in pursuance of the directive in the Constitution, the Planning Commission took up the matter and drew up a comprehensive scheme through its Prohibition Inquiry Committee. Since then, prohibition has been introduced in several states in whole or in part, though paucity of the financial resources of the states is the primary reason for the failure to fully implement this directive so far. It would be only candid to record that ultimately failure of the people to imbibe the Gandhian ideal of life is at the back of this failure. The spread of malady of intoxication amongst the younger generation since independence is in fact alarming. It should be pointed out that a fresh impetus was given to the program of prohibition by the Janata Prime Minister Mr. Desai, a staunch advocate of the Gandhian philosophy in this matter. As to the separation of the executive from the judiciary, Article 50, the slow progress and diverse methods for the various states has been replaced by the uniform system by union legislation in the shape of the Criminal Procedure Code 1973, which has placed the function of judicial trial in hands of the judicial magistrate who are members of the judiciary and are under the complete control of the High Court. Besides the directive contained in Part 4, there are certain other directives addressed to the state in other parts of the Constitution. Those directives are also non-justiciable. These are Article 350A enjoins every state and every local authority within the state to provide adequate facilities for instruction in the mother tongue at the primary stage of education to children belonging to linguistic minority groups. Article 351 enjoins the union to promote the spread of the Hindi language and to develop it so that it may serve as a medium of expression of all the elements of the composite culture of India. Article 335 enjoins that claims of the member of the scheduled caste and scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in the making of the appointments to services and posts in connection with the affairs of the union or of a state. Though the directives contain Article 335, 350A, 351 are not included in Part 4, courts have given similar attention to them on the application of the principle that all parts of the Constitution should be read together. Though these directives are not enforceable by the courts, and if the government of any day fails to carry out these objects, no court can make the government ensure them. Yet these principles have been declared to be fundamental in the governance of the country, and it shall be duty of the state to apply these principles in making laws. The sanction behind them is in fact political. As Dr. Ambedkar observed in the Constituent Assembly, if any government ignores them, they will certainly have to answer for them before the electorate at the election time. It would be a patent weapon at the hands of the opposition to discredit the government on the ground that any of its executive or legislative acts is opposed to the directive principles. The author discerns a more effective sanction for enforcement of the directives, which does not appear to have been properly appreciated in any quarters so far. Article 355 says. Whether Article 355, 365 can be applied to enforce implementation of directives by the state, it shall be the duty of the union to ensure that the government of every state is carried on in accordance with the provisions of this Constitution. Indisputably, Part 4, containing the directive principles, is a part of the Constitution. On the other hand, even though the directives are not enforceable in the courts of law, Article 37 unequivocally enjoins that it shall be the duty of the state to apply these principles in making laws. If so, it should be the duty of the Union to see that every state takes a step for implementing the directives as far as possible. Hence, it should be competent for the Union to issue directions against particular states to introduce free and compulsory education for children, or to prevent slaughter of cows, calves, and other milch and draught cattle, or to introduce prohibition of consumption of alcoholic drinks, and so on. In case of refusal to comply with such directions issued by the Union, it may apply Article 365 against such recalcitrant state. Otherwise, the directives in Part 4 shall ever remain a dead letter. Owing to the legal deficiencies of the directives and utility of their incorporation in the Constitution, which is the legal instrument, has been questioned from different quarters. Sir Abor Jennings thus characterized them as pious aspiration, and also questioned the utility of importing into India the 19th century English philosophy of Fabian socialism without the socialism. Professor Weir has criticized them in stronger terms. When one peruses the terms of these articles, or cannot deny that it would be foolish to allow courts to concern themselves with these matters. It may be doubted whether there is any gain on balance in introducing these paragraphs of generalities into a constitution anywhere at all. If it is intended that the Constitution should command the respect as well as affection of the people, if the Constitution is to be taken seriously, the interpretation and fulfillment of the general objects of policy will raise great difficulties for legislatures, and these difficulties will bring the Constitution, the courts, and the legislature into conflict and disrepute. If these declarations are, however, to be treated as words, they will bring discredit upon the Constitution also. Nevertheless, their incorporation in the Constitution has been justified by the consensus of opinion as well as the working of the Constitution since 1950. Sir B.N. Rao, who advised the division of individual rights into two categories, those which are enforceable in the court and those which were not, stated that the latter class, which are known in the Constitution as directives, were intended as moral precepts for the authorities of the state. They have at least an educative value. The educative value is to remind those in power for the time being that the goal of the Indian polity is to introduce socialism in the economic sphere. Panikkar, or economic democracy as distinguished from the political democracy. Ambedkar, which simply means one man, one vote. It reminds the authorities that they must ensure social security and better standards of sanitation, and emphasizes the duty towards women and children and the obligations toward backward and tribal classes. Panikkar. Granville Austin considers these directives to be aimed at furthering the goals of the social revolution, or to foster this revolution by establishing the conditions necessary for its achievement. He explains, by establishing these positive obligations of the state, the members of the Constituent Assembly made it the responsibility of future Indian governments to find the middle way between individual liberty and public good, between preserving the property and the privilege of the few and bestowing benefits on the many, in order to liberate the powers of all men equally for contribution to the common good. In short, the directive emphasizes an implication of the preamble that the goal of the Indian polity is not laissez-faire but a welfare state, where the state has a positive duty to ensure to its citizens social and economic justice and dignity of the individual. It would serve as an instrument of instructions upon all future governments irrespective of their party creeds. The socialistic approach has been further emphasized by the 42nd and 44th Amendment Acts as pointed out earlier. Those the directives are not enforceable by the court, and if the government of the day fails to carry out these objects, no court can make the government ensure them. Yet these principles have been declared to be fundamental in the governance of the country, and the government which rests on popular vote can hardly ignore them while shaping its polity. Again, while the time of the drafting of the constitution, the directives were considered by many as surpluses because they were not justiciable. The working of the constitution during the last few years has demonstrated the utility of the directives even in the courts. Thus, though the courts cannot declare a law to be invalid on the ground that it contravenes a directive principle, nevertheless, the constitutional validity of many laws has been maintained with reference to the directives so that they do not serve as mere moral homily. As Professor Weir had anticipated in 1950, for instance, it has been held that when a law is challenged as constituting an invasion of the fundamental right is specified in Article 14 or 19, the court would uphold the validity of such law if it had been made to implement a directive holding that it constituted a reasonable classification for the purpose of Article 14. The reasonable restriction under Article 19 or public purpose within the meaning of Article 31. The Constitution has since been amended to dispense with the need for judicial interpretation to reach the above conclusion. In 1971, Article 31C was inserted in the Constitution to provide that law to implement Article 39B to C would be immune from the limitation imposed by Article 14, 19 or 31. In 1976, this protection was extended to any law to give effect to any of the directives studied in Part 4 by the 42nd Amendment Act. The Supreme Court has, however, resisted that extension. Even as regard fundamental rights other than those under Article 14, 19 and 31, though the directives cannot directly override them in determining the scope and ambit of the fundamental rights themselves, the court may not entirely ignore the directive principles and should adopt the principle of harmonious construction so as to give effect to both as much as possible. Again, the Supreme Court has relied upon Article 39A in determining the duty of the state in making a law under Article 21 depriving a person of his personal liberty, and held that where a prisoner has a right of appeal, the state should provide him a free copy of judgment and also engage a counsel for him at the cost of the state. Not only in the matter of determining the constitutional validity of a legislation, but also in its interpretation of statutes, the court should bear in mind the directive principles are not in conflict with but complementary to the fundamental rights, and enable the state to impose certain duties upon the citizens insofar as the directives are implemented in making a law to ensure maximum wages to workers in accordance with the directive in Article 43. Though the directive principles as such are not enforceable by the courts, of late the Supreme Court is issuing directives in proper cases enjoining the government to perform their positive duties to achieve the goals envisaged by the directives. On the other hand, the Constitution itself has been amended successively, as for example, 1st, 4th, 17th, 25th, 42nd, and 45th, Fourth Amendments to modify those fundamental rights by reason of whose existence the state was experiencing difficulty in effecting agrarian, economic, and social reforms, which was envisaged by the directive principle. Thanks, regards.